Tēnā koutou katoa. Good morning. Thank you, Water New Zealand, for giving me this opportunity. Although I was working at Ministry for the Environment when John asked me to present on this topic, and I was leading the review of the Drinking Water NES at the time. And having seen John's submissions to the Havelock North Inquiry, and I think he described his pointed criticism of government, I was a bit reluctant initially. I thought he might be setting me up. And then when I saw that I was going to be preceded by an international expert on water safety and followed by an international expert on best international practice for managing catchment risk, I knew I was right. Somewhat daunting, but still here goes. Now, I no longer work for MFE, but I've been given the mandate to represent them today, and a number of MFE personnel are in the audience today. What do I do here? Nope. Tried every button. They're old. Sorry about that. Cheers. So the overall regulatory framework for for managing catchment risk in New Zealand is the Resource Management Act itself. For example, sections 30 and 70 around managing effects of activities. The National Policy Statement for Freshwater Management and its requirements to use an integrated catchment approach to improve water quality. But most specifically, it's the Resource Management National Environmental Standards for Sources of Human Drinking Water regulations, which are regulations overseen by MFE. For the benefit of our international visitors, I won't use too many acronyms, but I will refer to this one as the Drinking Water NES. We have I just thought I'd touch on the other NESs we have, just a bit of context. So they cover relatively important topics, air quality, and you can see the list there. This is the list of the NESs that have been released in chronological order, and you see that the bottom few are a work in progress. So the Drinking Water NES was a relatively early one, gazetted in 2007, came into effect in 2008. They aim to provide some national consistency to how these things are managed. They can be quite prescriptive. They apply to a range of activities, and they take effect immediately, so they immediately override local government plans. Although there are a couple of considerations to take into account there, which I'll discuss as we go on. Now, just before the NES was developed, there was concern that water suppliers had limited control over activities in the catchments they sourced water from, unless it was from a protected catchment like Auckland, from the Hunua and Waitakere ranges. In other areas, they had very limited control over the quality of the source water they had to treat. And suppliers were unlikely to be informed of a change of activities in the catchments which may decrease the source of the water quality, so they really didn't know what they were getting. Now the NES was put in place to attempt to remedy this, and you may have an idea of whether it's worked or not. So the primary objective is to reduce the risk. The first guiding principle that Dr. Hururi talked about and Dr. Bartram added to is preventative measures, and that's source protection. That source protection is paramount. The NES contributes to a multiple barrier protection system, which we've also heard a lot about, and it brings the catchment considerations into drinking water management. So it was really brought in to fill a gap where Section 70 of the RMA required regional councils to consider the effects of activities on a range of environmental outcomes, but not specifically drinking water. So it brought in that requirement for regional councils to explicitly consider drinking water in resource consenting and in regional plans. Now, important point is this is not to say that it only applies to regional councils. It won't work unless district councils, as primary water suppliers in many regions, are in close discussions, collaboration with regional councils on the activities that are occurring in the drinking water catchments. And further, actually, district councils have a specific obligation under the NES, which I know from talking to many of them, they are unaware of. So, as we know, there are multiple barriers. During the Havelock inquiry, actually, the concept of barriers was discussed in detail, and it included there was general agreement that say training of people and keeping up to date with best practice and I guess events like this is a barrier in a sense. But in this context, with water supplies being divided into three components of source, treatment plant, and the distribution or the supply, these are the barriers that we're talking about in the sort of the regulatory context. Now, the NES applies to the source and before the water is abstracted by a drinking water treatment plant. Note that the borehead itself is considered the treatment plant if untreated groundwater is the source. And of course, in the regulatory context, it's the first stage, and the Ministry of Health legislation then standards then come in to the treatment, and etc., and the Building Act in regards to plumbing and such. So the NES, what does it apply to? So that the point really is the concentration of determinants at the abstraction point of a water treatment plant used for a registered drinking water supply. Now, pretty much all of those terms were the subject of some discussion during the Havelock inquiry and whether people understood what they all meant and whether it was sufficient. I'll cover that a little bit more. Specifically, the NES applies to resource consents, that's regulations 6, 7 and 8, permitted activity rules and regional plans, regulations 9 and 10, and regulations 11 and 12 require emergency notification conditions for relevant consents, and this is where the district council consents come into play. Whoops. Out of sync. So that was that one. As far as resource consents goes, it applies only to water permits and discharge permits. When it was first drafted, there was a suggestion that it would apply to other activities, but it doesn't at the moment, or it doesn't. Where that activity may affect registered drinking water supplying greater than 500 people for 60 or more calendar days a year, and the rule of thumb is that consent must be declined if the activity will result in determinants exceeding the maximum acceptable value after existing treatment. So by way of a little walking through this a bit, if a regional council receives an application for a water take or a discharge permit, which requires a consent, and it is upstream or up gradient of a registered drinking water supply, supplying greater than 500 people for 60 days or more in a calendar year, it needs to be assessed for its effect on concentrations of determinants at the abstraction point of the supply. So the effects considered are different depending on whether the water is monitored and tested in accordance with the drinking water standards. If the water is not monitored and tested in accordance with the standards, no increase in the level of determinant is allowable. If the water is monitored and tested, any increase in the level of any determinant must not exceed the MAV, the maximum acceptable value for that determinant as specified in the guideline values. So if the activity will do that, have an increase, the consents must be declined. So this green bit, the big question mark, we know is the difficult bit. It's the understanding and predicting and modelling the effects of an activity on a drinking water source. We've heard that is very challenging. And other things that have been raised during the Havelock inquiries is sort of other activities which aren't captured by it. So the rule of thumb for resource consents is this, that any new activity must not deteriorate receiving water quality in a drinking water source to the extent that existing treatment processes cannot make that water safe for people to drink. So effectively you can't have an activity which is going to require additional treatment to make it potable. In regional plans, the permitted activity rules, the same criteria apply, the greater than 500 people, 60 more days, the same effects on the MAVs, and it applies to all activities regulated by regional councils, and effectively a regional plan or a regional council must not include a rule in a regional plan that allows permitted activity upstream, up gradient of an abstraction point if that activity is likely to result in the drinking water becoming unsuitable for human consumption. Or more simply, you can't have a permitted activity rule likely to result in drinking water becoming unsuitable for human consumption. Now this is actually quite similar to what's required for regional councils anyway under the section 70 of the RMA, where they are required to consider the effects of permitted activities on other aspects such as stock drinking water and recreational uses, and that the test in section 70 is quite similar to what would be required under the NES, and that the regional council must be satisfied that none of those effects are likely to arise in receiving waters before those activities can be permitted. The NES just makes it explicit that drinking water is to be considered when developing the plan. So regulations 11 and 12 apply to emergency notification conditions, and it requires the consent authority to assess whether any activity could pose a risk to drinking water supply in the case of pretty much any unintended event, such as a spill or an accident or heavy rainfall. If the consent authority considers that a risk such as this exists, a condition must be placed on the consent that requires the consent holder to notify the drinking water supplier if such an event occurs. Now, I'm not too sure if this is too much of a problem, whether it just happens, and that if an event happens, if a spill happens, that everyone just sort of knows to contact the drinking water supplier. But there is this requirement that there must be a consent condition. And so this is all activities regulated by both district councils and regional councils, and also that the population affected changes to greater than 25 people or more. So it's much smaller supplies. It's far more supplies and it's far more activities. So during the Havelock inquiry, the NES has been subject of a fair degree of discussion. MFE is undertaking a review of the NES. It's been around for nearly 10 years. So they are looking at how it's being implemented in regional plans and in consenting processes, and more importantly, is it actually being effective at meeting its objectives? Issues raised during the inquiry in stage 1, the report noted that there was a failure to recognise and embrace the NES, and there's an indication that it may not have achieved its objective of bringing all of the relevant organisations together. Into stage 2, a lot of submissions, a lot of conversations during the inquiry have focused on a range of different aspects of the NES, including whether upstream, whether just activities have taken place upstream and up gradient of the water supply, captures all of the risks, and that you can have activities perhaps downstream, down gradient, but I'm not a technical person, but I understand as per the zone of influence or the cone of influence, those activities could in fact be affecting the source. So perhaps that upstream upgradient isn't quite capturing everything that it needs to. The definition of abstraction point, is it the bore, or is it more than that? The location of supplies was noted by many councils as a frustrating point, not really knowing where they all are, and some aren't registered. And I think that while the NES, there's really kind of not a lot to it as far as what needs to be understood. It's actually how to do it is the hard part. The actual assessing this activity that's taking place perhaps 2 kilometres away from a drinking water source, is it upstream? What's the geology between here and there, and the geography, and I mean, how do we model and predict the effects, given things can change between the actual the activity, the discharge might be happening there. How do we actually predict it? And obviously there's some good work on this, but it's certainly not easy. Now, as I said, it only applies to water permits and discharge permits, so other activities taking place are not captured by it, various land use activities. The permitted activity rules that potentially have remained unchanged since the release of the NES is actually valid, even though it's been around 10 years, and you might have thought that regional plans would have been reviewed in 10 years. Not all of them have been, and not all component parts of their plans have been reviewed. So, and the NES doesn't require, even though it takes place immediately, it doesn't require that the permitted activity rules be changed until such time as a scheduled review of the plan is actually underway, or a plan change or variation that relates to that existing rule is introduced. So we could actually have permitted activities which we would rather they weren't permitted, but they still are, given the NES doesn't require that change until such time. The fact that the populations supply, the affected populations vary from 500 in some parts of it to 25, and the drinking water standards is usually 100. I think that, bringing all this, the affected populations considerations for drinking water, for registered supplies is worth lining up, or certainly considering. And then that one about district council's awareness of their actual obligations under the NES. And that's about it. Thank you.